Appreciate you all being here. I got to tell you, though, I wish I didn't have to compel you all to be here. We asked you as legislative liaisons to come participate with us, in which you refused. So the Committee on Oversight will come to order, and without objection, the Chair is authorized to declare a recess at any time. We have a couple goals for the hearing in our investigation and our need to do our constitutional duty. One, the FBI needs to produce its full investigative file to the United States Congress. And I mean the full file, not just the parts the FBI deemed relevant. Right now we only have the 302s handpicked by the FBI. We decide what's relevant, not the Department of Justice, not the FBI. We're entitled to the full file. Two, all unclassified portions of the file should be released to the public as quickly as possible. It has been more than 20 days since I'm sure the very first FOIA request was put out there, and by law that should be out there. I want to commend the FBI for already releasing its investigative summary report and Secretary Clinton's 302 interview summary to the public. We do appreciate that, and it's duly noted. But there are still a number of 302s left for the FBI to release. We were surprised to learn that the 302s, the so-called investigative files provided to the United States Congress, at least to the security officer, were only a portion of them, not all of them. And three, all members of Congress should be able to review the entire file. Right now, unless you're part of the Intel Committee, Oversight Committee, the Judiciary Committee, and the Appropriations Committee, these are if you're a member, you have to be on those committees in order to view what is currently in the SCIF. It's unclear to me how the FBI can prevent a member of Congress from seeing what we're already allowed to see by law, yet here they have done so. Even the unclassified information, that's what's mystifying to me. Even the unclassified information you're preventing members of Congress from seeing. But we do believe we should be able to see the file and the whole file. And it's disappointing that we are here today. We have a number of questions about the redactions, the classifications. I thought a number of those things would best be answered in a briefing. You know, Elijah Cummings, the ranking member here, has made a point on several occasions that rather than just going right into a hearing, let's go to a briefing. We had legitimate questions. We did have this plan for last week. We did have more than 12 members of the Congress show up to have that briefing, and none of you showed up. That's inexcusable. You're the congressional affairs officers. It's your job to talk to Congress. And for some of you, I had to threaten to send a subpoena just to get you to appear today. We did some math. We got 70 of you sitting here. Between your compensation and your benefits package, you make more than $1 million from taxpayers. Taxpayers are paying you more than $1 million. And you won't even come talk to Congress. What do you do all day if you don't talk to Congress? That's your job. So we're going to do that today. And the irony here is we're trying to protect the classified information. I didn't create this mess. Hillary Clinton created this mess. There are years of federal records. Some of it's so classified, none of us in this room should probably see them. Most of it's unclassified. But we have a duty and an obligation to protect that information. I believe that's probably the same goal that you have. But we're going to have a reality check here. She's the one that took the records from the State Department, gave access to people who don't have security clearances. The case is closed. There's no consequences, nobody being held accountable. But we also had an FBI director come and testify that he never looked at her testimony under oath. And somehow we have a classified system and we have a non-classified system, and somehow information was going from the classified system into a non-classified system. So it's ironic that you don't want to appear before this committee out of a concern for protecting classified information when Hillary Clinton walked around with a BlackBerry full of classified information and gave access to sensitive federal records to folks without security clearances at all. I want to understand from each of you what it is you think that Congress should not see. See, I believe passionately in the role of Congress. I believe passionately in the Oversight and Government Reform Committee. We were founded in 1814. Every expenditure, everything we do in this Congress, or everything we do in this nation is supposed to be overseen by us. We can investigate anything at any time. That's what's different about the United States of America. We're different because we are self-critical. We do go look under the hood. We do hold people accountable. That's why when Abraham Lincoln joined the United States Congress, he was on this committee. And he peppered the president because he didn't believe that the Mexican-American War started as the president said it was. And there's been a rich history of that throughout generations. We can't do that when each of the agencies that you all represent decide that, well, we're just going to show you the relevant information. We're not even going to answer your questions. You can't see those documents. That's the way a banana republic acts. It's not the way the United States of America acts. So we expect better, and we expect you to be responsive. And I don't expect to have to issue a subpoena to see unclassified information. While we can't be certain what is under each of the redactions within the documents, as far as we can tell, the redactions are covering information commonly given to Congress, such as names of key fact witnesses, titles and positions of government employees at the State Department, and Gmail accounts. There's nothing classified about that information. While I understand there's an argument to withhold information under the Privacy Act or the Freedom of Information Act, neither of those apply to Congress or any other committees. As I understand it, the FBI is not withholding any information based on the Privacy Act. Instead, they just don't want to give us the information. So there's really no legal basis for these redactions. The FBI also chose to redact any information in the report classified above secret. This also makes no sense. As a member of Congress, we routinely receive documents and briefings from the intelligence community at the highest levels of classification, with the exception of sources, methods, with the exception of the SAP material. So any redactions have to be based on classification that have to be removed. We have to be able to see that information. We also have questions on what the FBI file contains. Oddly enough, the copies of the file provided to us by the FBI are different. We are very grateful that they provided the first set on a Tuesday. I believe it was August 16th. The next day, we got a second set. Problem is, the second set had 27 emails more than the other one, which we were grateful for. It was an improving file. Only to have the FBI try to come back and recover those. Not because it was SAP material, because it's embarrassing. That's why it was embarrassing. But we should have had it in the first round. We should have had it at the very beginning. I also want to put this request in context because it's far from the first time Congress or even this committee has requested an investigative file from the FBI or the Department of Justice. Congressional committees are routinely provided investigative materials by the Department of Justice and the FBI. I ask unanimous consent to enter into the record the 2007 CRS report. This was done when things were going on with the dismissal of the U.S. attorneys. I'm going to read, it's a little bit long, but this is as good a summary as why Congress should be able to see this as anything. And I've got to read a few sentences here. From the CRS, a review of the historical experience and legal rulings pertinent to congressional access to information regarding the law enforcement activities of the Department of Justice indicates that in the last 85 years, Congress has consistently sought and obtained deliberative prosecutorial memoranda and the testimony of line attorneys, FBI field agents, and other subordinate agency employees regarding the conduct of open and closed cases in the course of innumerable investigations of the Department of Justice activities. These investigations have encompassed virtually every component of the Department of Justice and its officials' employees, from the Attorney General down to the subordinate level personnel. It appears that the fact that an agency such as the Justice Department has determined for its own internal purposes that a particular item should not be disclosed, or that the information sought should come from one of the committees or subcommittees does not prevent either the House of Congress or its committees or subcommittees from obtaining or publishing information it considers essential for the proper performance of its constitutional functions. There appears to be no court precedent that impresses the threshold burden on committees to demonstrate, for example, quote, a substantial reason to believe wrongdoing occurred, end quote, before a jurisdictional committee may seek disclosure with respect to the conduct of specific open and closed criminal and civil cases. Indeed, the case law is quite the contrary. An inquiring committee need only show that the information sought is within the broad spectrum of the matter of its authorized jurisdiction, is in aid of a legitimate legislative function, and is pertinent to the area of concern. And it goes on for page after page after page of precedent here. Basically, there is no legal reason why you should withhold any of this information from the United States Congress. This goes back from the Teapot Dome bribery scandal to Valerie Plame to what was done by Chairman Waxman when he requested the FBI 302s for President Bush, Vice President Cheney, Karl Rove, and several other senior advisors. I have two other things that I'd like to enter into the record. I ask unanimous consent to enter into this, to enter the CRS report, as well as the December 3rd, 2007 letter from Chairman Waxman to Attorney General Mukasey in the record. Without objection, so ordered. I'd also ask unanimous consent to enter the September 10th, 2007 letter from Chairman Conyers to Attorney General Gonzalez into the record. Without objection, so ordered. And finally, I want to commend the FBI for making its summary report and 302 of Secretary Clinton public. I do appreciate that. It's a good start. It's a good start. But it's time we be candid and honest with the American people. We allow Congress to do its job. I didn't pick this timeline. Hillary Clinton picked this timeline. I don't care about the election, what time it is. We're going to keep going at this full speed ahead. It is far, far too important. With that, I will now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. To the witnesses, I hope that as you listen to the chairman, if you think that the cases that he has cited, previous cases involving, for example, the U.S. attorneys are distinguishable from what's happening here today, I'd just like to know. I think he makes a very good point, other than the fact that I guess in some of those cases at least, the Justice Department was accused of doing something wrong. But I'd like to know exactly where you all stand on that, because I think he makes a very good point. Well, here we are again, another day in the Oversight Committee, another emergency hearing about Hillary Clinton. Today is the second hearing about Secretary Clinton we have held in 3 business days, and tomorrow we will have a third. For the record, Mr. Chairman, I want to thank you, and I want the American public to know that you have agreed to schedule a hearing on EpiPen, which affects so many of our constituents, because that too is an emergency situation for the constituents of every member who sits here in this chamber right now. As far as I can tell, the only emergency is that the election is less than 2 months away. The real reason for today's hearing is that FBI Director James Comey refused to be summoned before this committee yet again. He refused. Director Comey has already bent over backwards, departed from long-standing law enforcement precedent, and provided our committee with an unmatched level of transparency about his internal decision-making regarding this investigation. First, he announced the results of his investigation publicly. Normally, the FBI does not discuss its internal decision-making, but Director Comey did so in this case. Second, he agreed to testify in an emergency hearing before our committee 48 hours after his announcement. It's the FBI director. He sat right there in the witness chair, and he testified about the evidence they obtained, the law they applied, and the decision-making process they employed. He described how, quote, an all-star team, unquote, of career FBI investigators came to the unanimous conclusion, and how it wasn't even close. But the Republicans did not like the answers Director Comey gave. So they demanded copies of the FBI's internal investigative files. Again, in sharp break from past precedent, the FBI director agreed to share documents from the investigation in an effort to put this question to rest. But again, that was not enough for the Republicans, so they demanded the public release of these documents. Yet again, Director Comey broke from precedent. He released the FBI's internal investigative memo and the notes from their interview with Secretary Clinton. Let me say the obvious here. No matter what Director Comey does, it will never be enough for the Republicans. They are demanding that he bring criminal charges against Secretary Clinton, despite the fact that the evidence simply is not there. And that is something nobody with integrity would ever do. We sat here and we listened to Director Comey say that there were two things that matter most to him in his life. He said his family and his reputation. Last week, the Republicans wanted Director Comey to come up here one more time. But this time, he said enough is enough. He spoke with Chairman Chaffetz personally, and he told him enough is enough. In response, the chairman rushed to call today's emergency hearing. He dashed out letters as late as Thursday night, threatening even more subpoenas. The problem is that he invited the wrong people. The witnesses here today are the legislative affairs staffers from the FBI and other agencies. They did not make the decisions the chairman is upset about. Those decisions were made by none other than Director Comey. The chairman has a problem with Director Comey. He should take it up with him, not beat up on legislative affairs staffers because the FBI director wants no part of any partisan charade. The FBI's legislative affairs staffer have been in his job for just a few weeks, Mr. Herring, and is currently serving in an acting capacity. He's been very responsive with our committee, and it makes no sense to hammer him just because he's following the directives of his boss, Director Comey. The whole hearing is a bait and switch. I have the invitation letters right here, and the chairman says that this hearing will be held in a classified session. I ask unanimous consent to put them in the record, your letters about this hearing.
Without objection, so ordered.
Thank you. So that is what these witnesses prepared for. I don't know whether they spent their weekends preparing for a classified hearing or not, but I assume they did. They did not prepare to answer questions in an open session. So what are we doing here? At the last minute, the chairman decided to hold this hearing in open session to try to generate more headlines rather than obtain the classified information he claims to seek. It is fundamentally unfair and irresponsible to force these witnesses to answer questions about this issue in open session. As we have all heard, the classification level of these documents have changed repeatedly, and dozens of highly trained diplomats did not think many of them were classified. These witnesses should not be forced to make surprise, on-the-spot determinations about what they can and cannot say in an open session. After all, we've had debates for the last several months about what's classified and what isn't classified. So not only is this unfair, but it risks the inadvertent disclosure of classified information. We should hold this hearing in a closed session, like the chairman said he would in his letter, rather than gather the information and then review the written transcript to determine what can be released publicly and what cannot. That is how a responsible approach would look But that is not what is happening here. I guess this is what happens when you try to schedule a public attack against Hillary Clinton for every day of the week. You get frantic and you swap substantive discussions for set-up hearings and cheap press hits. Democrats on this committee have serious questions, and by the way, Republicans have serious questions. It's not just the Democrats, about our broken classification system. Even the chairman agreed with me last week that this system is broken and we need to work together to do something about it. And we all have, I think, have concerns about why so many of these documents were retroactively classified long after they were sent. But the only way to have that productive, substantive discussion is to go into closed session, as the chairman's letter stated. The only reason for the hearing today is open is because the Republicans know a closed hearing won't be on camera. And so with that, Mr. Chairman, I yield back and thank you.
I thank the gentleman, and with some indulgence, the ranking member knows it is a requirement in House rules to go into a non-classified setting, to an open session prior to going into a classified setting. We have set up in the House Visitor Center the classified room that will be closed to the public and the press. We are prepared to go into that setting, but we're required by House rules to first come into this open session first. It does require a vote of the committee.
With the chairman, you?
Sure.
Mr. Chairman, I guess it would have been helpful if you had laid that out from the beginning, because as I said to you up here at the dais and yesterday and on the floor of the House, one of my concerns was that I don't want,
testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Thank you. Let the record reflect that the witnesses all answered in the affirmative. In order to allow time for discussion, we would appreciate it if you would limit your questions or your comments to 5 minutes. I'm not sure who has an opening statement and who doesn't. We haven't been submitted anything. Mr. Kadzik, do you have any open comments?
No, I do not have an opening statement, Mr. Chairman, but I would note for the record that I was not compelled to be here today. I came here voluntarily.
Let the record reflect that none of them ultimately accepted service in terms of accepting the subpoena. I'm just saying in general, it did require us to get to the point where I signed subpoenas and presented those subpoenas, but all of the witnesses here today ultimately came here voluntarily. And I appreciate you highlighting that.
I'm not sure who those subpoenas were produced to, but they were.
And Mr. Kadzik was not one of those people. Let's be clear here. Yes, Ms. Freifeld.
I don't have a formal opening statement, but I did want to clarify, sir, that I did not refuse to come up. We asked clarifications on what exactly you were looking for because it seemed uncertain to us what you asked the State Department about these documents that were produced by the FBI. So I'm happy to be here and try to answer your questions as best I can.
Mr. Herring.
Thank you, Mr. Chairman. I do have a few opening remarks to make.
Yes, you're now recognized.
Thank you, Mr. Chairman. Mr. Cummings.
You can move that microphone just straight up right on there. Yeah, there you go. Thanks.
Better. Thank you, Mr. Chairman, Mr. Cummings, members of the committee, for the opportunity to discuss our production of documents in this highly unusual case with intense public interest. I am Special Agent Jason Herring, the Acting Assistant Director for the FBI's Office of Congressional Affairs. In early July, Director Comey appeared before this committee and answered questions for almost 5 hours to explain the FBI's investigation and conclusions regarding the email matter. At that hearing, and at every opportunity since then, Director Comey has promised that the FBI would be as transparent and forthcoming in this investigation as we could responsibly be. To that end, on August the 16th, the FBI provided to our congressional oversight committees a number of investigative documents to the investigation. It included an investigative summary of the factual information uncovered during the course of our investigation, the relevant FBI interview reports, sometimes known as 302s, and the emails that were determined to contain classified information. We produced these documents to satisfy the committee's immediate oversight interest in the FBI's conduct in this investigation. This was an unprecedented production and one made with extraordinary speed. We did this because we believe it's important for our oversight committees to understand how the FBI reached our conclusion in light of intense public interest in this case. I am not here today to discuss the merits of the investigation, but rather to discuss and answer process-related questions with the production of our investigative case materials to this committee and our other oversight committees. From my conversations with committee staff late last week, I believe I have an understanding of some of the committee's questions and would like to address those issues head-on and up front as best I can. In order to do that, I do need to be in a closed classified setting. I'll reserve the remainder of my opening remarks for when we go to the closed classified setting. Thank you. Thank
you. Ms. Walsh.
Thank you, Mr. Chairman. I have a brief opening statement on behalf of my intelligence community colleagues in the interest of brevity. Mr. Chairman, Ranking Member Cummings, and members of the committee, my name is Deirdre Walsh, and I serve as Director of Legislative Affairs for the Director of National Intelligence, James Clapper. I'm here in response to the committee's request to answer questions about the recent document production by the FBI to Congress related to former Secretary of State Clinton's email. While I understand the Intelligence Community Inspector General, or ICIG as we refer to him, may have interacted with the interagency with regard to these documents, by statute, the ICIG maintains his own interactions with the Congress separate from my office. Accordingly, I cannot speak on behalf of the ICIG. With regard to the documents produced by the FBI and the subject of this hearing, ODNI was not involved with this document production. I will, however, do my best to answer any of the questions that you may have. Additionally, I'm joined by my colleagues from the Central Intelligence Agency, the National Geospatial Intelligence Agency, and the National Security Agency in response to the committee's request. Given the classification of the underlying material, we look forward to discussing sensitive matters in the closed portion of the hearing. Thank you for the opportunity.
Thank you. It's my understanding, Mr. Higgins, Mr. Samuel, and Mr. Soul, that Ms. Walsh's statements reflect the IC. Okay. We'll now recognize myself for the first set of questions. Mr. Herring, what information do you believe that Congress does not have the right to see?
So we believe it's important for oversight committees to understand how the FBI reached our conclusion.
No, wait. I'm asking you a philosophical question here. What does Congress not have the right to see?
So I don't know if I can answer that in a way that, I think there's more to it than a simple answer. I think that each case is sort of specific to its own set of facts. I think Director Comey tried to be as transparent as he could with this committee.
Do you think he could be
other committees as he responsibly can be? So I think when he spoke and he answered questions.
Wait. What is it that I, as a member of Congress, or any member on this Congress, either side of the aisle, what is it that you believe we don't have the right to see? See, this is the way our government works. We get to do oversight. That's why since 1814 this committee has been doing that. There's executive privilege. Let me help you. There's executive privilege. Has the President invoked executive privilege in this case?
No.
The answer is no. Good. That's right. The answer is no. Is there any other situation?
Look, when it comes to classified information and the classification that deals in the executive order, not all the information that we have in our files belongs to us. We defer to other agencies when it comes to access to their classified information.
But you are the ones that put redactions on personal identifiable information, correct?
We did on the personal identifiable information, that's correct.
Where in the Constitution does it say that I can't see that?
Does it address it specifically in the Constitution?
So, can you cite any legal case, any precedent that says that Congress can't look at personal identifiable information?
I cannot cite any legal case.
Are you aware that Congress is exempt from the Privacy Act?
I am.
Does the FBI treat congressional document requests as FOIA requests?
No.
Will the FBI provide Congress all of the 302s?
All of the 302s, we have one set that you've been provided already. The rest of them are coming through the FOIA process.
Wait.
Yep.
We're not, FOIA process? You mean I got to fill out a FOIA request?
You can. Not necessary.
When, here's the problem. You handpicked the 302s to give to us. My understanding of discussion with staff, and I appreciate your accessibility with the staff. You've been good, and you're new, and for your first time hearing, this is a tough one, but the reality is you should give us all the 302s.
So let me say this. I think that the director made principled decisions about what to say to Congress when he was here and also what to provide to Congress. As far as the
Wait, where do I find that?
Personally identifiable.
Do we just let everybody in government decide that they're based on their own individual principles? That's what see, it's trust but verify is how it works. You don't get to decide what I get to see. I get to see it all. I was elected by some 800,000 people to come to Congress and see classified information. I was elected by my colleagues here to be the chairman of this committee. That's the way our Constitution works. Will the FBI provide to Congress the full file with no redactions of personal identifiable information?
I cannot make that commitment sitting here today.
Then I'm going to issue a subpoena, and I'm going to do it right now. So let's go. I've signed this subpoena. We want all the 302s, and we would like the full file. You can accept service on behalf of the FBI?
Certainly.
You are hereby served. We have a duty and a responsibility. You can cite no precedent, nothing in the Constitution, no legal precedent. You know this is important to us. You now have your subpoena. We would all like to see this information. I've gone past my time, or coming up on going past my time. I'll now recognize the ranking member, Mr. Cummings.
You've been in the job 4 weeks. I can't hear you.
Yes, sir.
And you used to work for one of our distinguished colleagues, Mr. Goodlatte, is that right?
Yes, sir.
Republican. So I'm going to, so you're familiar with Congress then?
Yes, sir.
I'm going to save most of my questions for the classified session, but I do want to address the redaction issue briefly. When the FBI produced these materials to Congress, their cover letter stated, and I quote, "The FBI has redacted personally identifiable information as appropriate," end of quote. Chairman Chaffetz publicly announced he wanted the FBI to lift these redactions. He stated, and I quote, "We are going to call on the FBI this week, to give a version where there is non-classified, the unclassified material and the classified material redacted so that could be out there in the public," end of quote. The problem is that there is no legitimate basis for the demand. Director Comey has already provided us with an unprecedented level of transparency into the FBI's investigation and internal decision-making. Now, I want to stop there for a moment. And you said yourself, I think at least twice, that there has been unprecedented discovery here. I mean, what did you mean by that? I don't want to take the words out of your mouth.
No,
Correct me if I'm wrong.
I think in this particular case, we don't typically make our case files available. They're sort of internal work product. There's a lot of sensitive information in there. Even the unclassified stuff is sensitive to a great deal. I think that we made a principled decision with redacting the PII only for those individuals who are not already in the public domain. And you sort of ask, why did you do that? Well, from my perspective as an agent, in any investigation, including a high-profile investigation like this one, or any other investigation really, it's critical for us as FBI agents to obtain cooperation from members of the public. As we go out and we talk to members of the public in any case, we need them to be willing to participate in the judicial process. A lot of times their initial reaction is, you know what, I don't want to get involved. As an agent, you talk to somebody, you try to protect them as best you can. Sometimes you have to call them as a witness at trial. Sometimes you don't. But witnesses who speak with us need to have confidence that they can talk to the FBI without risk of undue exposure. In this case, we are concerned about lifting the PII redactions for individuals who are not already in the public domain. That might have a chilling effect on the willingness of other members of the public in the future to cooperate with us, particularly in an investigation like this. And so I think that Director Comey's or what we as an agency tried to do was to satisfy the needs of the Oversight Committee by letting you all see exactly what we did in our investigation, the investigative steps we took, and how we came to that conclusion. I think he did it in the form of taking questions for more than 4 hours, but also making our files available, and that's not something that we typically do. We did make a principled decision as far as how are we going to affect this, how are we going to give that visibility to our oversight committees. We made a very thoughtful, I think, response in redacting only limited PII for the people that are not already in the public. And really, from my perspective as an agent, this is Jason talking.
How long have you been an agent?
17 years.
Okay.
And so, from my perspective as an agent, I think we have to protect the integrity of our investigations. And I don't want there to be a chilling effect, or I wouldn't want there to be a chilling effect for other people cooperating in similar cases like this going forward.
Well, one of the things that I asked Director Comey about was this whole process when you've got the Congress getting more and more information from the FBI, and whether it would have a chilling effect. Do we place ourselves in a position where if the Congress does not like a decision made by the agency, then dig, I mean, how much, how often will that be happening? In other words, so that chilling effect, and then I wonder, will other people, if a decision, somebody in Congress doesn't like the decision, do we set more and more precedents so that people can come in behind? And Director Comey said he had an all-star group of agents, and they had a unanimous decision. And I just, but you were talking about the chilling effect. So do you think that? But first of all, who made the decision with regard to the redactions? Since that's what we're supposed to be here about. I mean, I'm just curious who makes those decisions.
I think that was made at the highest levels in the Bureau.
And does that mean Director Comey?
Absolutely.
All right.
If I could say just sort of.
Please do. I thought I had some time, but go ahead.
I mean, I do think it's reasonable to think there would be a chilling effect. This is a very public case. Everybody out there is watching it. And we start lifting personally identifiable information, I think that potentially could have some impact going forward. I do think, though, that we're not trying to play hide the ball with Congress. We want Congress to be able to do its job, this particular oversight committee to do its job, and to understand really, what we did in the investigation, how we came to that conclusion, and we did that in part by, releasing the investigative summary and the 302s.
Thank you very much.
Thank you.
Some of the 302s. And when you don't show up at a meeting that we request behind closed doors, kind of lose that opportunity.
If I could.
Now we're going to recognize the gentleman from South Carolina, Mr. Gowdy.
Agent Herring, did the FBI interview the sender of all emails that contain classified information?
I don't know the answer to that question, only because I'm a ledge affairs guy. I was on the investigative team.
Can you find out? You would agree with me it'd be important. I mean, you'd want to interview the person who sent the classified information, right?
Certainly.
Because the recipient thought the C was just the third letter in the alphabet. You might be curious whether or not the sender also was clueless in the way he or she viewed classified information, would you not?
That would be a logical investigative step.
Can you find out whether or not you interviewed the sender of all emails that contain classified information?
Certainly.
Do you know if the sender of any of the classified emails knew that the information was classified at the time?
I don't personally know that. I wasn't part of the investigative team. I'm sure that.
Can you find out?
Certainly.
Can you find out for me?
Yes, sir.
There are folks wondering how information gets from a classified source into an email. Did your investigation shed any light on how classified information could get from a classified system into an unclassified email to even be sent? I'm not even talking about the receiving of it. I'm talking about the sending of it.
I'm sure they did look at that. That would be sort of a logical question you would ask as an investigator in a case like this.
That's what I thought.
But in my legislative sort of affairs capacity, I just don't have that kind of visibility.
Well, don't sell yourself short. You used to be an agent, right? Still an agent, right? So you know what you're doing. Did the FBI grant immunity to anyone during the course of its investigation?
For immunity questions, I'd have to defer to the Department of Justice for that. It wouldn't be an agent who would grant that kind of thing.
Did the Bureau recommend the granting of immunity?
I do not know.
Do you know whether the Department of Justice granted immunity to any witnesses?
I know I saw some articles last week, but that's the extent of
Well,
it.
surely you got better sources than the media for that, don't you? You can ask the guy sitting 2 people down from you.
I would have to defer to the Department of Justice, sir.
Do you know whether any witnesses asserted any privileges while they were being interviewed?
I don't know.
But the Bureau would know that, right? Because they would have asserted the privilege while you were in there.
I'm sorry?
The Bureau would know that, right? Because that privilege would have been asserted perhaps while you were in there conducting the interview.
What kind of privilege are you talking about, like attorney-client privilege?
Oh, there are a bunch of privileges. There's priest-penitent. I'm guessing that one didn't come up. There's doctor-patient. I'm guessing that one didn't come up. There's the Fifth Amendment privilege against incrimination. That one might have come up. Attorney-client privilege, again, there have been media reports that one came up.
Sir, I just don't know the answer to those questions.
Have you ever had the attorney-client privilege come up during any of your investigations?
Certainly.
Who does the privilege belong to?
The client?
So the client can waive it, right?
Can.
You understand why Congress might want to know whether or not the attorney-client privilege was waived and who the client was?
I can certainly imagine.
Yeah, me too. That's why we want to see the file, Agent. I mean, you say it's unprecedented. Mr. Cummings used to be a criminal defense attorney. He got to see all your 302s. Ken Buck used to be an assistant United States attorney. He got to see all your 302s. Probation officers get to see all your 302s. Why can't Congress?
Sir, I think we have tried to provide the information in a way that is understandable. I think the investigative summary tells kind of the story, and I do think that the 302s that we provided are the important ones.
Well, let me ask you this. If those summaries were all anyone ever needed, why don't you just introduce those in trial? Why actually call the witness?
Well, certainly we actually trying to make your life a little bit easier in the light of the
But see, I don't want my life being made easier. I don't want that. I want to know what was said in the 302s. Because the 302 is itself a summary of an interview, right? It's not a verbatim transcript.
That's correct.
So you have given me the summary of an interview. And I'm not asking for a verbatim transcript because you don't have one. Certainly. I'm just asking for the 302. So I don't have to read your summary. I may read the 302 differently from the way you read it. So why not?
So I think we've given you the relevant ones as we've
relevant according to whom? I am telling you, I don't think you've given me all the relevant 302s.
Well, the remainder of the 302s will come out through the FOIA process.
But since when did Congress have to go through FOIA
Correct.
to obtain 302s from an investigation that's not even resulting in any prosecutions that your boss has already said is over? Since when did we have to go through FOIA?
So I think that the 302s we have provided, I think that we made a principled decision about what to provide. It was certainly made at the highest levels of my agency.
All right, I'm out of time. That's what that knocking sounds. I'm just going to say with all due respect, you don't get to decide what we think is relevant. And I do say that respectfully. The defense attorneys get it all. I think Congress ought to get it all.
Thank the gentleman. We'll now recognize the gentlewoman from New York, Ms. Maloney, for 5 minutes.
Well, thank you, Mr. Chairman, and I'm going to reserve my questions to the closed session, but I would like to clear up some misconceptions. I would say that the campaign season is upon us, and the accusations and the charges and the attacks are almost out of control. I just spent, I won't get into it, but anyway, for several weeks, the chairman has been appearing on national television saying that the reason that he cannot see these emails is because the FBI produced to Congress is because they are such a highly sensitive, classified, high level. And for example, he stated that these materials were, and I would like to put his quote in the record, so secure and sensitive that even I, as the chairman of the Oversight Committee, did not have the proper clearance to see it. But in fact, as I understand it, Mr. Herring, Chairman Chaffetz has not been able to view these documents. The reason he hasn't been able to see them is because the Republican chairman of the Intelligence Committee has not allowed him to do so. The documents were produced and given to the Intelligence Committee, and the Intelligence Committee has a process by which they release the documents to people, and he has the same clearance as any other member of Congress who's not on the Intelligence Committee. And so the reason he hasn't been able to get them is because his own party's leadership has not voted to give him this clearance. Now, as I understand it, the FBI produced a small subset of these emails only to the Intelligence Committee. And according to House rules, the Intelligence Committee has the jurisdiction over certain agencies, and these agencies report to the Intelligence Committee. So it has a process in place. And for any member who's not on the Intelligence Committee to see these documents, and they need to send a letter to the committee, which Chairman Chaffetz did, and I have his letter from September 2nd, and I request unanimous consent to place it into the record.
Without objections to order.
Okay, so he sent this letter saying he'd like to see them and ask permission, and the Intelligence Committee needs to take a vote. Now, as I understand it, the chairman of the committee has not scheduled the vote that would allow the chairman to see these documents. Now, I just feel that a lot of this is just pure, plain politics as usual, stirring up a hornet's nest over documents he can't see, which are being withheld by his own party. And it seems that they do not want to open up the Intelligence Committee's jurisdiction at this point. I don't know why they're not taking the vote that would allow him to see these documents. But what our committee is engaged in is nothing, in my opinion, nothing more than a partisan election bashing exercise stating that these emails can't be seen when they can be seen if his own party votes to let him see it. So I just say that it's politics as usual, and I'm disturbed about it. There is a problem with the classification system. We all saw that in the last hearing. Let's work together to correct it. But this whole charade is just that, a charade. These documents are not being withheld from the chairman because of anything any of these witnesses have done. They are being withheld by the Republican chairman of the Intelligence Committee. So I respectfully suggest to my chairman that we bring in the chairman of the Intelligence Committee and ask him why he doesn't have a vote and release the documents to you. It is not the FBI, but the House Select Committee on Intelligence who's withholding these documents. So,
will the gentlewoman yield?
I most certainly will.
Any one of the four people from the intelligence community here can help answer this. Have you made redactions on personal identifiable information to the Intel Committee? Mr. Higgins, how about you?
No, we have not.
There's no redactions at the... Ms. Walsh?
Not to my knowledge.
Mr. Samuel?
No, Mr. Chairman, not to my knowledge.
Mr. Sewell?
No, Mr. Chairman, not to my knowledge.
Can you release these emails into the public? And if so, what would happen? Mr. Higgins, what happens if we release these emails that are on Hillary Clinton's unsecured server? What happens?
Mr. Chairman, I can confirm that CIA participated in a classification review process, and I'd be happy to talk about that process in closed session. Needless to say, some of the materials do include classified information that we do not believe is appropriate for public release.
And are some of these materials include sources and methods?
Mr. Chairman, I'd prefer to discuss any further matters relating to classification in closed session.
gentlewoman's time has expired, but thank you so much for yielding to me. I
But
do appreciate
reclaiming my time, I get to close in my time. You took all my time. I thought the chairman could have, I think the chairman can have all the time he wants. I'd just like to conclude by saying, and I just ask for a second, just a second, what our committee is engaged in is nothing but a partisan attack on Secretary Clinton with an effort to harm or undermine her presidential campaign. That's all it is. Get the chairman of the Intelligence Committee to release the documents to you. No one is withholding it. The Intelligence Committee has jurisdiction over agencies, including the FBI. They release their information. They have a process. You have appealed to that process. Let's wait for that process. Ask him why he's not taking a vote to give you access to these documents. You're making it look like there's some conspiracy or some terrible thing happening when it's really nothing but a partisan attack on Secretary Clinton.
I thank the gentlewoman, and I guess with some indulgence, where I have a problem is when they redact information that is deemed unclassified. I don't understand that. It makes no sense. And classification is one issue, but when they redact information that has already been designated as unclassified, I believe that Congress should be able to see that.
Mr. Chairman, may I respond?
Sure. Yeah.
In the hearings that we've had, the witnesses have testified that personal information that has been redacted has been to protect the privacy of people and personal information. Now that's on record. But in the classified section, we can have more of this clarified.
Thank you. And I appreciate the dialogue back and forth. Now let's recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Mr. Herring, let me just follow up where the chairman was. So did the FBI make the redactions dealing with personal identifiable information?
We did, yes.
You did. That's what I figured. Okay, Mr. Herring, you've said we don't have all the 302s, we don't have the whole file, and what you did give us, as you just pointed out, had lots of redactions.
Yes, sir.
And the chairman invited you to a briefing last week in a classified setting, which you said in your opening remarks where you'd like to discuss this information. So who told you not to come to the briefing? Because the chairman was there, I was there. In fact, every single Republican member was sitting there waiting anxiously for you to come do what you just said in your opening statement you wanted to do. So why didn't you show up?
So let me say a couple things here, if I could, just to sort of be clear. As far as the 302s and what we've provided and what we haven't provided, are a lot of 302s, there are dozens of them, and we prioritized up front what we thought were the most important ones. And so those are the ones we gave.
But you got them all, don't you?
A couple of weeks. We do have, and we're working on the others.
So you can get the paper, you can give it to us, or frankly, you could have told us what you just told us right there. You could have told us that last Wednesday, but you didn't come. So why didn't you come?
So I actually want to address it in the classified setting, if I could. There was certainly
someone tell you not to come, Mr. Herring?
There were some conversations between me and some of the committee staff about what the briefing was going to be about.
No, I'm asking, did someone tell you not to come? You were invited, we were all waiting. We don't have all the 302s, we don't have the whole file. You've told us you made all the redactions. We were going to ask you about that. We were going to do it in a classified setting, which is what you preferred, what you want, what you've told us today you want, and someone told you not to come. Who told you not to come?
It was my decision, but I'd like to explain it away in the classified
Wait.
setting.
You decided on your own? You didn't consult with anyone else?
Certainly consulted with the director's office.
And the director said, it's up to you, Mr. Herring. I'm not going to decide. You're going to decide? Really?
So a lot of it has to do with what the discussion was going to be in the classified briefing. And I think there was some confusion, at least on my part, about what the expectations were in some of my conversations with committee staff last week.
Do you have any other discussion? Just you and Director Comey talked about this? You talked to anyone else?
Certainly, we have our general counsel's office, the Department of Justice. There are a number of people.
Mr. Herring, was this case different? You said you've been around the FBI 17 years. You're now the acting director for legislative affairs. Was this case different?
I think this case is different in a lot of ways.
A lot of ways.
I do.
Can you tell us? Can you give me some? Why? I know it's different in a lot of ways. How about this difference? You ever had a case in your 17 years where the subject of your investigation's husband meets with the Attorney General just a couple days before you're going to interview that individual in your investigation. You ever had that happen in your 17 years?
No, sir.
That's certainly different, isn't it?
Yes, sir.
Yeah, you ever have a case in your 17 years, and we appreciate your service, you ever have a case where the Attorney General announces publicly that she's going to follow the recommendations of the FBI, even though she has no idea what those recommendations are going to be, based on, you ever have that happen in your 17 years?
Not in one of the cases I was assigned.
Yeah. Well, I don't think it's ever happened because the Attorney General told me she's never done that until this time. Certainly. You ever in your 17 years, you ever have a director of the FBI, you ever have them do a big press conference, walk through all the wrongdoings of the person under investigation? You ever have that happen, a big press conference before, and then make this big announcement? Or normally the FBI just kind of announces whether they're going to prosecute or not, right? You ever seen that before?
I mean, we certainly have press conferences, not quite like that one.
Not quite like that one. That's exactly right. And then have you ever had this? Now, maybe this happens, but Mr. Cummings said in his opening statement, Republicans didn't like the answers Mr. Comey gave. Well, that may be true, but based on what Mr. Comey did last week, where he sent a memo to you and all your colleagues, looks to me like a lot of former FBI agents, and maybe some even current ones, didn't like some of the answers they got from this investigation. You ever seen that before? Mr. Comey says in this letter, I explained to our alums, I'm okay if folks have a different view of this investigation. So there's obviously some folks who used to work in the Justice Department didn't like the outcome either. Now, they may be Republicans like Mr. Cummings says. They may not be. So I've never seen that before either. Have you, Mr. Herring?
Frequently, we get messages from the director on a variety of things.
Yeah.
I think in
2 months after he makes the announcements, he thinks it's important to send a memo out to 2 months later to all his employees and saying, hey, I better fill you in on some things here, why we did what we did. You ever have that happen 2 months after the fact?
I think oftentimes he wants the employees to understand what's going on and full level of transparency both outside the Bureau and inside the Bureau. We're a big
2
agency.
months later, you got a memo.
36,000 or so employees.
This case was different, but here's the problem, Mr. Herring. It's not supposed to be. It's not supposed to be different. Everyone is supposed to be treated equally under the law. And I know deep down you know that. You're 17 years serving in our government. You know that, don't you? Everyone's supposed to be treated the same. And in this case, this individual was treated different. And everyone in this country knows it. And that's why we're having this hearing. And that's why we'd have liked you there last week to give us the information a little sooner than later tonight when we go into a classified setting.
So can I answer that? I mean, I think it's important for us as an agency to be apolitical, to follow the facts in any case where it takes us. And I do believe that we follow the facts in this particular case. And Director Comey certainly made a very difficult decision. But ultimately it is the Department of Justice who makes the determination of prosecution.
No, hold on.
Real quick, not in this situation, because she said she was going to take his recommendation.
The gentleman's time has expired.
It's a false statement.
We're now going to recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. First of all, I want to thank you for your service. And then, regrettably, second of all, I need to apologize for the way that you're being treated here today. I know that we've worked with a number of you in the past, and appreciate your service to the country. And like some folks here, I recognize the separation of powers. While I do agree that Congress has a very wide jurisdiction for investigation, I also know that we are not a law enforcement agency. We are not a trial agency. And under the separation of powers in this country, it's not consistent with the Constitution for the legislative branch to overturn a decision, especially on an investigation, in a potentially criminal investigation and you've decided not to prosecute. It is completely out of bounds for Congress to overturn a decision of the court on one specific case. And I want to go back right to the beginning. The notice of this hearing, which was supposed to be closed, and so I apologize that you're being lambasted and denigrated in public when you were asked here to come here to a closed hearing. And all this is happening out of bounds and totally inconsistent with the chairman's letter that this would be a closed hearing. There is a relevant case law, and Mr. Herring, I would say that there is constitutional language that would prohibit what's going on here today in requiring you to divulge the names of individuals that have been redacted during your investigation, and that constitutional language is in the Bill of Rights, and particularly the Fifth Amendment. And I want to go back to a case called Watkins versus the United States. This was a matter brought forward by Senator Joe McCarthy in the House Committee on Un-American Activities. And Watkins was brought forward, he was subpoenaed to testify before the House Committee on Un-American Activities, and Chief Justice Warren delivered the opinion of the court in that case. And he said there's no general authority to expose the private affairs of individuals without justifications in terms of the functions of Congress. Nor is the Congress a law enforcement or trial agencies. These are the functions of the executive and judicial departments of government. No inquiry is an end in itself. It must be related to and in furtherance of a legitimate task of Congress. And investigations conducted solely for the personal aggrandizement of the investigators or to punish those investigated are indefensible. Now, the notice for this hearing says that, number one, the purpose is to review the redactions that were made by the FBI during their investigation. And, to review the redactions, omissions, and circumstances surrounding your investigation. Now, as you said before, Mr. Herring, in bringing witnesses forward to get them to cooperate with the FBI, well, look at it this way. If the law is correct the way the chairman and my Republican colleagues are looking at this, here's what we could do. This committee could identify somebody, we could refer somebody for investigation by you, our secret police, the FBI. You could go out and investigate all these people, and then we would have the ability to publicly embarrass them by removing any redactions that you put in place. That's the world that we could create here. And what is the one instance when this exercise, this overreach of power is being administered? It's when we're investigating the Democratic nominee for president a couple of months before the election. That's when this is going on. This is terrible. This is absolutely terrible. This is a miscarriage of justice. And the right of people against unreasonable search and seizures, the right of the witnesses that you investigated, and I understand this was a 12-month investigation. Earlier testimony, you said that you did 3 years of work in about 12 months and pulled in all these people. So if anybody at all is mentioned in any of these by a witness who mentions another person, that person will suffer the glare, and their lives will be turned upside down because of what this committee wants to do. And that is a violation of our Constitution and the individual rights of those individuals just from having been mentioned or being approached in an FBI investigation. So, Mr. Chairman, I think this is going in the totally wrong direction. This is a sad day in the history of this committee, I have to tell you. This is a sad goddamn day that we're doing this.
Gentleman's time has expired. I think the last comment
Not appropriate.
It was a bit inappropriate. I will now recognize the gentleman from Florida, Mr. Mike.
Thank you, Mr. Chairman. Mr. Herring, we do have an important responsibility of members of this committee, unlike any other committee in Congress. We're the Investigations and Oversight Committee. The chairman went through the history of the committee and some of the investigations. This particular case we're talking to, dealing with Secretary Clinton's emails, the case was declared closed by the director. Is that correct?
Yes.
Yeah. And that came after, and I pointed this out the day he was here, just an unprecedented series of events. And Mr. Jordan, I think, relayed some of the timetable. On Friday, July 1st, the Attorney General said she would take whatever recommendations FBI came up with. On Saturday, the 2nd of July, the vans pull up and they interviewed the witness for what, 4 hours, was it?
Something like that. I
Yeah,
don't really
something
recall.
like that. And I asked the questions if it was recorded, and was no. Did he participate in it? The director, no. Then we found out that there were the 302s that were taken. Is that correct? The summaries were taken.
A 302 for Ms. Clinton? Yes.
Yes. Okay. And then on July 5th, the 4th was a Monday, it was announced by the director there would be no prosecution or case closed by basically the Attorney General the next day. That's pretty much the sequence, isn't it?
I think he made that recommendation.
Yeah,
Yes.
and the case is closed. Now, I've been on the committee longer than anyone here. I can never remember an instance, and the chairman went back to before the Teapot Dome scandal, when even during some of these investigations, we have always had access to information, and that has been the case, hasn't it? That we've always had access, unfettered access. The committee, again, the chairman cited time after time.
I don't know about unfettered access before my time.
But we've gotten the information. Again, he has that, and I'd like it made part of the record, Mr. Chairman, the report that you have.
Without objection, so ordered.
Mm-hmm. And we do know that the secretary used a private server which had emails that contained classified information. Is that not right, Ms. Walsh? All this community would agree on that?
About her use of a private server, sir?
The secretary used a private server, and on it, and going through the server was classified information. I mean, everybody, unless you're on another planet, knows that, including these. They're all shaking their head affirmatively. The director, when he was here, said he didn't know if there was a possibility that it could have been hacked, that information could have been made public. We have really a national security issue here, too, that Congress, in its responsibility to investigate, is now being denied the information about what really took place. You're participating in keeping that information from us, Mr. Herring.
If I could just say a couple of things. You know, one, on the personally identifiable information, I obviously have a subpoena here for that now. I engaged Mr. Chaffetz's staff earlier today about a compromise that
well, we're going to get the 302s one way or another, but you have not given us all the 302s, right?
Not yet. We did prioritize them, and we did the most important.
That's not a question. You don't get to prioritize. Never in the history of investigations that I've participated in. We want the information. We are entitled to the information. We are the investigative branch. Collectively, we represent the American people.
Certainly.
And you have denied that. Now, we've had to file with you, Mr. Krasnick, a referral. How long before you act on the referral? You have the referrals?
We have the letter from the chairman and Chairman Goodlad.
What's the timetable? I mean,
I can't give you a timetable. We've referred it. It's being reviewed, and I can't give you a timetable for an investigation.
You are, again, withholding information that this committee legitimately requested the director is, and he promised that he would provide us. That's not acceptable.
Gentleman's
Chairman.
time has expired. Yes, the ranking
Chairman,
member.
just yield for just 1 second. Mr. Micah asked about, just asked a question that just sparked my interest. You said you were having discussions with the Republican staff. Is my staff involved in that, in those discussions? I'm just curious.
Not as of today, no, sir.
Not as of today?
Well, I had a conversation with Mr. Chaffetz's staff earlier today, but your staff was not a part of it, sir.
Is that your normal course of doing things?
No,
We do represent 700,000 people each.
Yes, sir.
Over here. And you are from the Congress. You worked with Goodlatte, is that right?
Yes, sir.
All right.
Now I recognize the gentleman from Virginia, Mr. Conley, for 5 minutes.
Thank you, Mr. Chairman. First of all, Mr. Chairman, there's an article that appeared today in Newsweek on emails in Newsweek magazine. I would ask that the article be entered into the record.
Without objection, so ordered.
And let me just read a little bit from this article. It says, Clinton's email habits look positively transparent when compared with the subpoena dodging, email hiding, private server using George W. Bush administration. Between 2003 and 2009, the Bush White House lost 22 million emails. 22 million. This correspondence included millions of emails written during the darkest period of America's recent history, when the Bush administration was ginning up support for what turned out to be a disastrous war in Iraq, with false claims that the country possessed weapons of mass destruction, and later when it was firing U.S. attorneys for political reasons. Like Clinton, the Bush White House used a private email server. It was owned by the Republican National Committee. And the Bush administration failed to store its emails as required by law, and then refused to comply with a congressional subpoena seeking some of those emails. I guess the past is prologue. The chairman mentioned that Abraham Lincoln was a member of this committee. Abraham Lincoln, maybe that wasn't auspicious, Mr. Chairman, because he only served 1 term and couldn't get elected back home. He was a Whig at the time. And he spent his time worried about things like the Wilmot Proviso, trying to end the slave traffic in Washington, D.C., the nation's capital, and fighting the slavocracy and trying to move this country to limit and ultimately abolish a very evil institution. That's what he spent his time doing. We're spending our time trying to pillory somebody about how she handled her emails while she was traveling the world on behalf of this country to 111 countries, trying to restore U.S. credibility in foreign policy after the incredible damage done in 8 years of the previous administration. I guess if I were in my friend's situation, I'd grasp at this straw too. Mr. Herring, my friend Mr. Jordan, tried to suggest that you, the FBI, have handled this case very differently than the normal course of justice to an American citizen. I guess because of the high-profile nature, you handled it very carefully. Is that correct?
Yes, it is.
So it was different in that sense. But we had Director Comey, who was a, by the way, registered Republican until very recently. We had him before our committee, and I asked him under oath, did the witness involved, the primary witness here, involving these emails, did she lie? No. Did she deceive? No. Did she evade? No. Did she obfuscate? No. Did she deliberately keep or withhold relevant information requested from the FBI? No. Is that your understanding as well?
I would refer to Director Comey's comments.
Mr. Micah says, or somebody said, you know, the case is closed, and you affirm that.
Yes.
Why? Why is the case closed? What's your understanding of that, Mr. Herring?
Decision made at the highest level.
And the decision was, according, you said you've read the newspapers, the director of the FBI says it wasn't even a close call. Is that your understanding?
Correct, yes.
Correct. No special treatment here. It wasn't even a close call. This is political theater. 302s, could you tell us what 302s are? My friend, Mr. Gowdy, knows what they are, but not all of us do. We're not all lawyers.
So 302 for us is a term of art. It's simply a form that which we summarize in an interview.
And how often do you provide 302s to Congress?
Rarely.
Rarely? Why?
Usually, we don't share the investigative files outside of the.
So our request is unusual. Is that correct? You said you don't do it very often.
Correct. Yes, in some sense it is. We don't get that request very often, and we certainly don't provide them very often.
And to protect people
Yes, sir.
from raw interviews. Is that correct?
From
Or the summaries of those interviews.
to protect people from. I'm sorry, I missed the.
From raw material from an interview.
Certainly.
Right. Redactions. How unusual are redactions? This is unique to this case. Is that correct?
No, we do redactions from time to time.
Why?
Really, as far as people do have privacy interests. Anytime we release documents outside of the FBI, if it's in FOIA, if it's another avenue, you have to review those and apply.
If the chairman will indulge me one more question,
Certainly.
and then I'll cease and desist.
Gladly.
Thank you, Mr. Chairman. Mr. Herring, were you told at any time before this hearing or at any other time during this process that this is highly political and you should cover up, obfuscate, evade, deceive, or not provide information to protect somebody from our scrutiny?
No, not at all.
Has anybody at this table?
Gentleman's time has expired. We have votes on the floor that are 10 minutes away. We have members who still haven't asked questions, plus we need to do a recorded vote. So we're going to have to leave it here and now recognize.
I appreciate the chairman's indulgence.
Gentleman from North Carolina, Mr. Meadows, for 5 minutes.
Thank you, Mr. Chairman. Mr. Herring, would you say that the FBI's investigation and the delivery of documents have been very systematic and principled?
Yes, as far as delivery of.
So there's no haphazard method of delivering documents?
The documents we provided to Congress, sir?
Yes.
No, I think it's been thoughtful and deliberative. And
Okay. Can you tell me why you didn't deliver the documents that the chairman asked for on July the 11th to the committee? You didn't deliver them to the committee. You actually delivered them to another entity, did you not?
That's correct. We delivered.
Why did you not deliver it to the committee?
Well, because those documents contain classified and other sensitive materials and need to make sure they're handled appropriately.
All right. So are you willing to deliver all the unclassified documents to this committee?
So I think that
Yes or no? Because you can't have the first statement without the second statement. If the reason you sent it there was because it was classified, are you willing to give all the unclassified documents to this committee?
So the documents that we
Yes or no?
We will give the. So we've given certain documents to the committee already.
Yes or no? It is a real simple question. Will you give all the unclassified documents to this committee, since the reason that you gave them to somebody else was that there was classified documents?
So the documents.
Yes or no?
The documents have the restrictions on them, and
Yes or no? Why would they have? Who placed the restrictions? You?
No.
FBI?
Yes.
So the answer is you place restrictions, so you're not going to give the unclassified documents to this committee.
So we've given this committee access to all the documents through.
That's not the question. It's a great answer to a question I didn't ask. Are you willing to give the unclassified documents to this committee?
All I can do is tell you that I'll take it back.
All right, so let me ask you another question, because you said that it was systematic. I went to the classified room, and there's two big binders there. One binder had some documents. The second binder that we got from the FBI had more documents than the first binder, and yet they were supposed to be identical. Would you say that was?
So I'd like to address this in the classified setting, if I could. I think
Was that an oversight?
I think the details are important of what the differences are.
But we just asked for a second copy, so would that not be haphazard? It doesn't seem too methodical, because when we went page for page, they didn't match up. So who made the decision to give us a different set?
I'd like to address that in the closed session, please.
Well, let me just say this. There was 27 new emails. There was a number of different types of information that didn't seem to go, and I don't want to share anything classified, so you admit that the first set and the second set were not identical.
They were not identical. There were some differences.
Okay. So what were the non-classification agency equities that prevented the initial disclosure of the 27 emails that we got in the second batch?
Again, classified session, I prefer to discuss.
Were all of those from one agency?
I would prefer to address it outside of the setting.
Okay, I understand that all of those were from one agency. Is that correct?
Look, the whole issue is sort of the handling of classified information.
So what was the agency?
I don't want to get into that here in this setting. I'm happy to answer your question.
Well, I have one of the emails that was withheld that said that it was later marked unclassified / CIA use only. So was that your justification for withholding it?
I'm sorry, I'm not sure I understand.
Well, it said unclassified CIA only. So, Mr. Higgins, let me come to you. Did you read those emails that were in the second batch?
Sir, I'd prefer to answer any questions about the classification review in a closed setting.
All right. So no reason why they were withheld.
I'd prefer to answer any questions about the classification
All right.
review in a closed
So I understand you're asking for those documents back. Is that correct? That's not classified. Are you asking for them back?
Sir, I'd prefer in a closed session to answer any questions about the classification review.
All right. Did Director Brennan talk to you about that, Mr. Higgins?
Again, sir, I'd prefer to answer those questions.
All right. I can see where this is leading. So let me finish by this saying, you have finished all the redaction. Is that correct, Mr. Herring, on what you gave us on the unclassified documents? The redaction, the copies that we got to see on those unclassified documents, are the redactions done?
For the ones that you all have,
Yes.
they're
All
not
right.
necessarily.
So will you comply with the federal law to release those in 20 days according to FOIA law? I'll yield back.
Sorry, what was the gentleman's answer? What was your answer to that question?
The redactions are completed for the ones that are here with Congress, the ones we've released. We're working on the remaining 302s. The PII redactions for the remaining 302s all in process.
Well, what I believe Mr. Meadows is asking is that under FOIA, there's a 20-day requirement to respond to a FOIA request. Now that we know that they're all done, will you release those within the 20-day time frame?
So I'm not a FOIA guy. They're not all completed for the other 302s.
Are there any that are completed?
I'm sorry?
Are there any that are completed?
I don't know the status. I don't know the status of all the
We'll go into that tomorrow. We've gone past our time. Let's now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. Mr. Herring, I want to give you a better chance to answer some of my colleague, Mr. Meadows' questions. First of all, your title is you are the Acting Assistant Director for Congressional Affairs of the FBI. Is that correct?
That's correct.
And you're in that post for how long?
About a month.
Did you say you used to work for Mr. Goodlatte?
I did a detail to the Hill, to the Judiciary, for about 15 months.
Oh, okay. And was that reporting to Mr. Goodlatte?
Certainly did. I was actually technically assigned to the crime subcommittee, and Sensenbrenner was the chair of that.
And the Goodlatte we're talking about is the Republican chairman of the House Judiciary Committee. Is that correct?
Yes, sir.
Okay. Now, you just were hammered with all of these yes or no questions, and I could see you having trouble with them. The trouble you were having, Mr. Herring, did not stem from your lifelong ambition to protect Secretary Clinton, did it?
No, sir.
No. All right. In fact, the pointed question that my good friend Mr. Meadows was going over and over about was, will you turn over certain documents, yes or no? You're unable to say yes or no because that's not your call. You have to take it back to the office and take it up the chain of instruction, don't you?
Yes, sir.
That's why you couldn't answer yes or no.
Certainly.
Well, how fair was it for anybody to hit you with that kind of yes or no question when you couldn't give a yes or no answer? How fair was that?
I'm here to answer the questions as best I can.
Yeah. And I wonder how fair it is to second-guess the FBI, officers who are sworn to uphold, defend, and protect our Constitution, and not caring where the political chips may fall. When Director Comey came in and testified, up until the time he decided not to prosecute, he was universally applauded on both sides of the aisle, particularly on the Republican side of the aisle, for his judgment, for his service, for his patriotism in this nation. And then, when it was his recommendation, which he now says was not even close, not to prosecute Secretary Clinton for the way she handled her email, all of a sudden he is reviled, and all of his decisions, up and down, are being second-guessed by the Republicans on this committee. I agree with my colleagues. This is nothing but a show trial. It is nothing but political theater. And the only reason, the exceptional reason that this is happening is that a couple of months from now, people are going to have to decide whether to vote for Secretary Clinton for president. Now, Ms. Fryfield, I'm sorry that you and the other witnesses are being put in this awkward position today. The chairman invited you to a classified hearing, but he is now springing this on you. I will withhold most of my questions to the classified bit of this, but we have to talk about the marking of classified documents. I mean, it's being bandied about that documents can't be produced because they're highly classified. Well, to be classified, according to the manual, which follows Executive Order 13526, a document has to have something that identifies who originally classified it. It has to identify the agency and office of origin of the classification. It must identify the reason for the classification. It must identify the date of the classification. And they typically also have a banner, both across the top and the bottom, stating the level of classification: top secret, confidential, eyes only, whatever it is. Ambassador Kennedy testified that none of the emails provided to Congress had any of these indicators, and at our hearing we asked Ambassador Kennedy about 3 documents, 3 out of 30,000, that included a small c in parentheses, even though the documents didn't have any of these other indicators for classified documents. State Department spokesman John Kirby said the markings on those emails were an error and they were not, quote, necessary or appropriate at the time they were sent as an actual email, and Ambassador Kennedy agreed. We asked him about one of those emails dated August 2nd, 2012, and he confirmed that the C in parentheses in that email was a mistake. He also confirmed that every paragraph in that email was also marked sensitive but unclassified. We asked Ambassador Kennedy whether the FBI consulted with the State Department about the classification status of this particular email, and he said he'd get back to us. My question to you is, do you know the status of that request, Ms. Fryfield?
I believe he's going to get you the answer in the next day or so.
I think
the next day or two. I thank you, and I yield back.
Thank the gentleman. It is the intention of the chair to exhaust the questioning appropriate for an opening session. But pursuant to House Rule 11, Clause 2G2, I move that part of the remainder of the hearing will be closed to all persons other than the members of the House, staff of the committee with appropriate security clearances, the official reporter, and the witnesses and their counsels with appropriate security clearances, because of the expected testimony received may include material designated as classified. Remind members that this is not a debatable motion. Pursuant to the House rules, the motion must be approved by a recorded vote. The question is on closing part of the remainder of the hearing to the public. And again, it's the intention of the chair to allow members to ask further questions in the unclassified setting and then go into the classified setting. So the clerk on the question is on the closing part of the remainder of the hearing to the public. The clerk will call the roll.
Mr. Chaffetz.
Aye.
Mr. Chaffetz votes yes. Mr. Mica. Mr. Mica votes yes. Mr. Turner. Mr. Turner votes yes. Mr. Duncan. Mr. Jordan. Mr. Wahlberg. Mr. Wahlberg votes yes. Mr. Amash. Mr. Amash votes yes. Mr. Gosar. Mr. Gosar votes yes. Mr. Desjardins. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Farenthold?
Yes.
Mr. Farenthold votes yes. Mrs. Lummis? Ms. Lummis votes yes. Mr. Massey? Yes. Mr. Massey votes yes. Mr. Meadows? Yes. Mr. Meadows votes yes. Mr. DeSantis? Yes. Mr. DeSantis votes yes. Mr. Mulvaney? Yes. Mr. Mulvaney votes yes. Mr. Buck? Mr. Walker? Mr. Blum? Yes. Mr. Blum votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Russell? Mr. Russell votes yes. Mr. Carter? Mr. Grothman? Yes. Mr. Grothman votes yes. Mr. Hurd? Yes. Mr. Hurd votes yes. Mr. Palmer? Yes. Mr. Palmer votes yes. Mr. Cummings? Yes. Mr. Cummings votes yes. Ms. Maloney? Ms. Norton? Mr. Clay? Mr. Clay votes yes. Mr. Lynch? Mr. Lynch votes yes. Mr. Cooper? Mr. Connolly?
Aye.
Mr. Connolly votes yes. Mr. Cartwright?
Yes.
Mr. Cartwright votes yes. Ms. Duckworth? Ms. Kelly? Ms. Lawrence? Mr. Liu? Ms. Watson-Coleman? Ms. Watson-Coleman votes yes. Ms. Plaskett? Mr. Desaulniers? Mr. Boyle? Mr. Welch? Ms. Lujan-Grisham?
Clerk will report the tally.
On this vote, there are 25 yeas and 0 nays.
The motion is adopted. It is the intention of the chair to reconvene here at 7:30, and then we will close out the remaining of the unclassified questions. We will then, at the appropriate time, depart for HVC 210, the Capitol Visitor Center, as it's been prepared for a closed hearing of the committee. Only members of the committee, designated committee staff, the official reporter, the witnesses, and their counsels may be present. The clerk is directed to allow only these persons to enter at that appropriate time. We stand in recess until 7:30.